established with the same motive. ASG Balbir Singh stated that in a broad spectrum, India wants to be a $5 trillion economy, and dispute resolution is one of the components of that economic activity, which would finally result in achieving this kind of number the government is looking at. Mr. Balbir Singh also emphasized on the need for having a trained pool of arbitrators to add value to the Indian system that not only include the Indian bar but also foreign lawyers coming to India. Mr. Tejas Karya, partner Shardul Amarchand and Mangaldas, spoke about the need for institutionalization of arbitration, use of technology, reduction of approaching courts in arbitration except in extreme cases. Emphasizing on one major benefit of institutional arbitration, he stated, no need to go to the court for appointment of arbitrators.
A very good evening to all present. I'm Riya Rathi, Member Advisory Board of the Indian Dispute Resolution Center, and I welcome all our esteemed guests and also thank each one of you for sparing your precious time to join us for this evening. Now I would like to request our Chief Guest, Honorable Mr. Justice M.R. Shah, Judge of the Supreme Court of India, to kindly grace the dais. I would also request Honorable Ms. Justice Indu Malhotra, former Judge of the Supreme Court of India, and Mr. Tushar Mehta, Solicitor General of India, Mr. Manan Kumar Mishra, Chairman Bar Council of India, to kindly grace the dais. I request our esteemed panelist, Mr. Tejas Karya, Partner and Head of Arbitration, Shardul Amarchand Mangaldas, Mr. Ratan Kumar Singh, Senior Advocate, and moderator for the panel discussion, Mr. Shashank Garg, Advocate, Delhi High Court, to kindly grace the dais. Now I would like to request everyone to rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य विन्ध्य हिमाचल यमुना गङ्गा उच्चल जलधितरङ्गा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
Thank you. Now, with permission, with the Honorable Chief Guest and Honorable Chair for today's panel, we would like to begin today's conclave. The IDRC's Arbitrate in India Conclave 2023 marks the third anniversary of the Indian Dispute Resolution Center, the IDRC. We embarked on this wonderful journey in May 2020 when Honorable Mr. Justice A.K. Sikri, former Judge of the Supreme Court of India, inaugurated IDRC. The IDRC is a not-for-profit institutional arbitration center. Its parent body, International Dispute Resolution Council, is registered with the Ministry of Commerce and Niti Aayog and empaneled with the Ministry of Law and Justice, Government of India. IDRC provides a state-of-the-art institutional environment for online as well as offline resolution of disputes through arbitration, mediation, conciliation, as well as expert determination and early neutral evaluation, using its cloud-based in-house e-ADR digital platform and through its affiliates across all the major cities in India and overseas. Now I would like to introduce our esteemed guests. The chief guest for today's event, Honorable Mr. Justice M.R. Shah, practiced for over 20 years in the Gujarat High Court in civil, criminal, constitutional, taxation, labor service, and company matters, and specialized in land, constitutional, education, excise, custom matters, and arbitration. Lordship served as additional standing counsel for the central government and for CBI. Justice Shah has also appeared in a large number of cases, including matters of constitutional importance and those which involve great public importance. In 2004, Lordship was appointed as the additional judge of the Honorable Gujarat High Court. He was sworn in as the Chief Justice in August 2018, and thereafter he was elevated to the Honorable Supreme Court in November 2018. In Lordship's Supreme Court tenure so far, he has authored around 712 judgments, which is a record of sorts. Lordship has authored landmark judgments in the field of arbitration, like Ellora Paper Mills Limited versus State of Madhya Pradesh, and recently Sri Vishnu Constructions and the Engineer-in-Chief Military Engineering Services, to name a few. I would like to invite Ms. Sumedha Sindhu Rathi, Member Secretary at Advisory Board of IDRC, to felicitate Lordship. Now I would like to introduce the chair of today's panel discussion, Honorable Ms. Justice Indhu Malhotra, enrolled as an advocate with Bar Council of Delhi in the year 1983. She qualified the AOR examination in 1988. Ladyship specialized in the law of arbitration and appeared as counsel in various domestic and international commercial arbitrations. As a prominent senior advocate, Ladyship dealt with several matters of constitutional and social importance. Some of the prominent cases were Indian Express Newspapers versus Union of India, Indira Sahni versus Union of India, MC Mehta versus Union of India, and Supreme Court Advocates on Record Association versus Union of India, and P.V. Narasimha Rao versus State, to name a few. Being one of the members of the Vishaka Committee, Justice Indhu Malhotra was member of the Supreme Court Gender Sensitization and Internal Complaints Committee from November 2013 to 2017. She was appointed as member of Justice B.N. Sri Krishna Committee on making international arbitration hub in India, constituted by the Ministry of Law and Justice, Government of India in 2017, to review the working of arbitral institutions in India, and to make recommendations for institutionalization of arbitration and suggest legislative amendments to the Arbitration and Conciliation Act 1996. Leadership on the bench of the Supreme Court of India has been part of several landmark judgments in the field of arbitration, namely NN Global Mercantile versus Indo Unique Flame, Dakshin Haryana Bijli versus Navigant Technologies, and BSNL versus Nortel Network, to name a few. Leadership, it's an honor to have you with us today. And may I please facilitate?
May I now please request Ms. Riya Rathi, Member, Indian Dispute Resolution Center, to facilitate, ma'am.
Now I would like to proceed with introducing our panelists for today's panel discussion. Mr. Tushar Mehta, the Solicitor General of India, began his career in 1987. He was designated as Senior Advocate in the year 2007 by the Gujarat High Court and was appointed as the Advocate General in 2008. Thereafter, Mr. Mehta was appointed as the Additional Solicitor General of India in 2014 and is serving as the Solicitor General since 2018. He has expertise in commercial and constitutional matters. And Mr. Tushar Mehta was member of the committee that drafted GST legislation. Tushar sir represented Government of India in several high-profile cases, including same-sex marriages most recently. Thank you, sir, for joining us today. And I would like to request Mr. Divyan Chanu Rathi, Honorary Secretary IDRC, to felicitate sir. Thank you. Next we have with us Mr. Manan Kumar Mishra, Chairman of the Bar Council of India. Mr. Mishra is a senior advocate in the Supreme Court and was unanimously elected as the Chairman of the Bar Council of India in 2014. He has been at the forefront of championing the rights of the bar as well as advocating strong views against any attack on judiciary of the country. Sir has enhanced the standard and quality of legal education, right from promoting legal education in schools to establishing India's first international university of legal research and education last year in Goa. It is our pleasure, sir, to collaborate with IIULER and Bar Council of India for organizing the Arbitrate in India Conclave. I would like to invite Advocate Chitragupt Dagar, Member Advisory Board IDRC, to felicitate sir. Thank you. Next we have with us Mr. Tejas Karya, partner Shardul Amarchand Mangaldas. He heads the arbitration practice of the firm, and Tejas sir has extensive experience in handling broad range of complex high-value international and domestic commercial disputes and frequently advises clients across diverse sectors. Tejas sir has contributed to policy formulation in the domain of arbitration. Sir has advised in drafting of amendments to the Arbitration and Conciliation Act 1996 and the Commercial Courts Commercial Division, Commercial Appellate Division of High Courts Bill 2015. Sir has also been part of the high-powered committee set up by the Government of India for institutionalization of arbitration in India. I would now request Advocate Adya Sridatta, Arbitrator IDRC, to felicitate sir. Thank you. Next we have with us is Mr. Ratan K. Singh, Senior Advocate and International Member, Keating Chambers, London. Ratan sir is one of the leading arbitrators and counsels who specializes in complex high-value construction, engineering, infrastructure, mining, and commercial litigation and arbitration in India, as well as internationally. From serving as the chair of tribunals to representing parties in he has broad experience in international arbitration under rules like ICC, UNCITRAL, SIAC, LCIA, DIAC, and others. Also, he is the founder chairman of the Society of Construction Law India, and he is director of the Chartered Institute of Arbitrators, India branch. Ratan sir has received several fellowships from numerous internationally reputed organizations. In fact, he is the only Indian to receive fellowship from International Construction Law Association. Ratan sir regularly delivers distinguished lectures all over the world and has also several publications in his name. I would now request Advocate Aishwarya Dash, Arbitrator IDRC, to felicitate Ratan sir. Thank you. Now I would like to introduce the moderator for today's panel discussion, Mr. Shashank Garg, Advocate, High Court of Delhi. Shashank sir is a well-known name in global arbitration space, known for his skills in international commercial arbitration, sports arbitration, construction law arbitration, as well as civil and commercial mediation and litigation. Sir has an experience of over 15 years before the Supreme Court of India and the Delhi High Court, as well as other judicial and quasi-judicial forums. He represents clients before the arbitral tribunals in ad hoc as well as institutional setup under all the leading institutions across the world, and also acts as an arbitrator. Currently, he is an independent counsel based in New Delhi, and before he started his own independent chamber practice, he was partner at Advani and Company. Sir has edited 2 books, namely Arbitrator's Handbook, published by LexisNexis in 2022, and Alternative Dispute Resolution, The Indian Perspective, published by the Oxford University Press in 2018. I would now request Ms. Priyanshi Agarwal, editor latestlaws.com, to felicitate sir. Thank you. Now we have a short video on introduction to the facilities and functions of Indian Dispute Resolution Center. We would like to play it. Thank you.
IDRC is an initiative of International Dispute Resolution Council, a company registered with the Ministry of Corporate Affairs, Government of India, and the Niti Aayog. IDRC is duly empaneled with the Ministry of Law and Justice, Government of India, for providing alternative dispute resolution services through arbitration, mediation, conciliation, early neutral evaluation, and expert determination to central and state government ministries, departments, private companies, organizations, public sector undertakings, and others. Dedicated to provide highly professional, efficient, and state-of-the-art institutional environment for both online and offline resolution of all kinds of disputes in a time-bound and cost-effective manner. The IDRC is located in India's capital city's most iconic location, the Barakhamba Road at Connaught Place in New Delhi, and its corporate office at Mumbai, apart from its NCR facility and affiliate centers spread across India and London, Singapore, and Malaysia.
The IDRC is supported by the Indian Institute of Dispute Resolution, an academic organization in the legal arena. It has expertise in varied legal fields and has its own training schools, as well as latestlaws.com, a leading name in the field of legal journalism, which has millions of patrons not only in India but around the world. IDRC was inaugurated by Honorable Mr. Justice A.K. Sikri, former Judge, Supreme Court of India and International Judge, Singapore International Commercial Court. IDRC received special mention and praise from Mr. Amitabh Kant, CEO, Niti Aayog, which was widely covered in the national media. IDRC has its own set of in-house IDRC Domestic Arbitration Rules 2019, which governs the conduct of the entire arbitration proceedings right from its commencement to its termination. IDRC maintains an in-house panel of esteemed arbitrators and mediators, which include former judges of Supreme Court of India, Chief Justices of High Courts, judges of High Courts and District Courts, as also senior advocates, Queen's Counsels, chartered accountants, company secretaries, architects, ex-PSU's heads, bureaucrats, corporate leaders and like. eADR software. IDRC has India's first of its kind online eADR facility hosted on secure cloud servers for conducting arbitration, mediation and conciliation. IDRC's eADR portal has following major components: personal dashboards, e-filing, e-booking, e-payment, virtual hearings, cloud servers with 24/7 access, e-allocation, e-notices, digital signatures, e-certified copy. IDRC's virtual ADR hearing portal is hosted on world's best secured cloud servers and manned by trained professionals. Its salient features are 24/7 online booking platform, facility to have up to 100 participants, secured with end-to-end encryption, breakout rooms for private consultation, licensed multi-channel video conferencing software, pay-you-money secure payment system, HD video and Dolby voice quality, technical support, option to record and preserve the hearings, secretarial and transcription services. So resolve your disputes today with the IDRC like never before. Indian Dispute Resolution Center, helping good people resolve.
Thank you. Now I would like to request our respected Chief Guest, Honorable Mr. Justice M.R. Shah, to please deliver the presidential address.
A very good afternoon to all of you. Respective panelists, Honorable Miss Justice Indu Malhotra ji, former Judge Supreme Court of India, my dear Tushar Mehta, Lord Solicitor General of India, Shri Manan Kumar Mishra, Senior Advocate and Chairman Bar Council of India, Shri Karia, Tejas Karia, Shri Ratan K. Singh, Shri Shashank Garg, the office bearers of the Indian Dispute Resolution Center, dear participants, ladies and gentlemen. It is a privilege to be invited to address the second Arbitrate in India Conclave 2023, jointly organized by the India International University of Legal Education and Research, Goa, in association with Indian Dispute Resolution Center, on a very important topic, namely making India a hub of international commercial arbitration. Current trends and challenges in arbitration in lieu of allowing foreign law firms in India. The increasing growth of global trade and the delay in disposal of cases in courts made it imperative to have the perception of alternative dispute resolution system, more particularly in the field of the commercial disputes. A fast-growing economy requires a reliable, stable dispute resolution process and mechanism in order to be able to attract foreign investment. With the extreme backlog of before the Indian courts, commercial players in India and abroad have developed a strong preference to resolve the disputes via arbitration. Timely resolution of the disputes, more particularly the commercial disputes, and the cost-effective is the need of the day. Various arbitration centers like the IDRC are catering the need of cost-effectiveness and the speedy disposal of the disputes, more particularly the commercial disputes. IDRC is an institutional arbitration center established by the International Dispute Resolution Council, registered with the Ministry of Corporate Affairs and Niti Aayog, and empaneled with Ministry of Law and Justice, Government of India. It gives a platform to all the stakeholders in the resolution of the commercial disputes by of arbitration, mediation, and conciliation. The IDRC Center provides offline as well as digital online EADR facility through its state-of-art e-arbitration, e-mediation, and e-conciliation software portal hosted on secure clouds. The portal provides various facilities which all of you know and you are aware. I am happy to note that the IDRC has accomplished more than 1,100 plus arbitration proceedings and thus have contributed in achieving the goal. Let's make the resolution in India a reality. Shri Divyansh Rathi, founder member as IDRC, is a very enthusiastic and young. I wish all the success to the IDRC in helping the people to resolve the disputes, more particularly in the field of commercial disputes. Today, there will be a discussion by the panelists, respected panelists like the Sri Sindhu Malhotra, Tushar Mehta, Tejas Karya, and other dignitaries on the dais on a very important subject, making India a hub of international commercial arbitration, current trends and challenges in arbitration in lieu of allowing foreign law firms in India. The Bar Council of India has published the Bar Council of India rules for registration and regulation of the foreign lawyers or foreign law firms in India. The rules now allow the foreign lawyers and the law firms to practice foreign and international law and the international arbitration matters in India in a regulated and controlled manner based on reciprocity. It may enhance the better quality of legal service. It may prove to be the cost effective. There shall be advantages and disadvantages in allowing the foreign lawyers and the foreign law firms in India, which shall be discussed in today's conclave. Shri Manan Kumar Mishra, the Chairman Bar Council, who is the pioneer and who has taken great pains to allow the foreign firms and foreign lawyers will throw more light on the subject. When we talk about the arbitration in India, first of all, we have to prepare ourselves to provide a platform in India. A time has now come to seriously think why, in the case of international arbitration or the disputes, the people go out of the country. What are the negative points and what India is not able to compete in the field of arbitration? It is a very serious thing which is required to be considered in depth and in detail. It is true that now so many arbitration centers have been established, but still much is to be done. We have to repose the confidence in the mind of the foreign investors that in India there will be speedy and timely resolution of the disputes. Minimal interference by the courts against the awards would strengthen the speedy and timely disposal. It is very unfortunate, and it is a hard reality that even for appointment of an arbitrator by the courts, application under Section 11 takes number of months and sometimes the years, which ultimately defeat the object and purpose of the arbitration. As and when required, the Supreme Court has intervened and issued various directions and the judgments emphasizing the need for speedy and timely resolution of the disputes, more particularly the commercial disputes. Because of various decisions of the Supreme Court, of which I am also a party to the decisions, faith of the foreign investors has been enhanced. However, a lot is required to be done so that the litigants may not go out of the country. I am sure that the establishment like IDRC shall cater the need in achieving their goal, arbitrate in India. I wish all the success to the today's conclave. There shall be healthy and valuable discussion in today's conclave on a very important subject noted here in above. The respective panelists will throw more light on the subject who as such are expert in the field of arbitration. I am thankful to the organization for giving me this opportunity to be with all of you and part of this conclave, and to give me this opportunity to share my views on the arbitrate in India. God bless all.
Thank you, Lordship, for your insightful talk and thoroughly engrossing articulation on the current scenario of arbitration in India. Lordship has some other prior engagements, so he would have to leave. But before that, we would like to request our esteemed guests to get a group photograph click together. Okay. So Lordship will be with us for the next 15 minutes. We are grateful for that. May I request all the guests for a group photograph? Thank you. you. And I would once again extend our heartfelt gratitude to Lordship for sparing his time and gracing the occasion. Now I would like to request Mr. Shashank Garg to please commence today's panel discussion. And also Mr. Divyan Chanu Rathi, the Honorary Secretary of IDRC, will join our panelists.
Good evening, everyone. Let me begin by thanking Honorable Justice M.R. Shah for a very stimulating address and setting the tone for this panel discussion. I would also like to congratulate IDRC for putting a stellar cast of panelists. I'm very, very privileged and honored to speak and ask questions to all the experts present on the dais. Now, we have limited time and a very interesting topic. Many of us who are in the field of arbitration have been hearing making India a hub of international commercial arbitration as a common topic of discussion for last 10 years. But in the last 10 years, the journey of the Indian arbitration ecosystem has been like a roller coaster. Lots of ups, very few downs, and all the stakeholders coming together to actually make this dream come true. So we cannot say that this is only a dream and only an idea, which 10 years ago when we used to sit in conferences and talk about make India a hub of international arbitration, everybody used to have a lot of doubts. There were questions asked to the judiciary, there were questions asked to the executive, there were questions asked to the practitioners. All of those questions have been answered successfully. So this is the time to ideate further and to ensure that what we have achieved is not lost. Let me, therefore, begin by asking a question to the chairperson of the panel discussion today, Honorable Justice Indu Malhotra. What are the key factors that parties consider when choosing a preferred seat for arbitration? And how does India fare in meeting these criteria compared to other successful jurisdictions around us?
In an international commercial arbitration, the criteria which a party looks at, one, that it should be a neutral place, because the seat of arbitration is called the juridical home of the arbitration, and the courts at the seat exercise a supervisory role. So the curial law, substantive law, will be governed by the seat of arbitration, so it's very critical. So one is the place should be neutral. It should have a good arbitration regime in place, particularly with respect to recognition of arbitration agreements and enforcement of awards. They certainly look very closely at the track record of the national courts in enforcing arbitration agreements and enforcement of awards, at what has been really the track record. Are the awards mostly enforced or not? Is public policy ever used as a ground to reject enforcement? So these are critical factors. Apart, and what is frankly speaking, I find, which is one of the factors which really has affected the image of India, is that, as Justice Shah pointed out, there is delay not only in the appointment process, but I think the more critical part is enforcement aspect. It's at section 34 that the proceedings get really stalled, and it takes a long, long time. So that is one of the issues which India certainly needs to address. And for that, my suggestion has always been that we need specialized benches in every court disposing of these matters expeditiously if we have to make India a hub of arbitration. Apart from that, availability of provisional remedies for preserving the status quo, a pool of competent arbitrators, and infrastructure, a good center which will conduct arbitral proceedings in accordance with international norms, with transcription facilities, interpreters, etc. It's not difficult to put it in place. India is certainly moving towards that with this, India International Arbitration Center having been made operational. So these are broadly, I think, the contours which one looks at while choosing a seat of arbitration. I think India has, since 2015, made significant strides, but where we seem to be lacking is the delay in enforcement. I don't think the courts in 90% cases have refused enforcement. Only thing is that it takes a long time for the entire process to get concluded.
Thank you, ma'am. Taking a cue from what you just said, my next question is for the Learned Solicitor General of India, being the top law officer of the country. Sir, India, there is a perception globally, or we could say a misconception globally about the reputation of Indian courts, even in the commercial sphere, to be extremely slow, whether it comes to appointment of arbitrators, whether it comes to setting aside proceedings or the enforcement proceedings as pointed out by leadership. What do you think we have done right, and what do you think should be done immediately by the stakeholders to completely clear the air and get rid of this misconception about India?
Am I audible? I'm audible. See, it's not a misconception fully. It is true that there is a slow pace insofar as the challenge to the arbitral awards are concerned. There are two aspects to it. A, if the parties who are of other jurisdictions or parties within India choose Indian arbitrators as the panel of arbitrators, then getting dates of the arbitrators have become very, very difficult. So the first delay is in completing the process itself. That is sought to be taken care of by the amendment in the Act. And now by and large we are getting the results in two ways. There is a time limit prescribed. Extension is not at the free will of the parties. You have to approach the competent court for extension. And number two, the number of arbitrations which an arbitrator can accept is one of the factors which has now started showing the results. So far as post-arbitration scenario is concerned, the difficulty is, and I would fully agree with the leadership, that you need specialized benches. But the scenario in the country at present is that it is always the concerned judge, be it a district court or a high court, who gets the business of dealing with Section 34 or Section 37 appeals. If we can think of a separate arbitration courts by itself, like separate tribunals for, say, insolvency, separate tribunals for GST regime, etc., with specialized judges who would deal with 34 and 37 proceedings, and simultaneously, subject to, of course, the limitations under the Indian Arbitration Act, if that is the law governing arbitration, then even execution proceedings can be entrusted to specialized courts rather than specialized benches of the same court. I think that can be a big step forward. Of course, these are my views in my capacity as a lawyer, but government is also very, very serious about giving a boost to arbitration as immediate and quick redressal mechanism. We are also looking at the arbitration as one of the key factors for the purpose of creating an incentivized atmosphere for the foreign investment in India, etc. So I'm sure whenever right time occurs, the legislature and the executive both would take appropriate steps. But the fulfilling thing is that the scenario 3 or 4 years before and the scenario today has completely changed. There are certain road breakers which go into the decision making of at least foreign investors, and India needs to address them. And I'm sure India, both at the executive level and at the legislative level, will address them.
So before I move on to Mr. Manan Kumar Mishra, I just had a follow-up question on what the Learned Solicitor General said. Maybe sir and the chairperson can answer this. With respect to making India a hub, we've been concentrating more, or at least all the good deeds that have been done have made Delhi certainly a hub of arbitration. But there is a lack of consistency when we see across the country with the high courts. Do you think, sir, this is a reason for worry, and do you think there should be some steps that should be taken to ensure that it ultimately the result should not be that Delhi becomes the hub of international arbitration and all other seats are not preferred at all, because the high courts do not seem to be consistent with their speed and views?
There have been centers which are set up. There's a center in Madras, which is the Nani Palkiwala Center. In Hyderabad, there's a center. I think all over the country, the states are taking a very progressive role so that in those regions, good centers are set up and which are functioning pretty well. So I think it's not really Delhi. Delhi, of course, being the capital, then Bombay is a commercial center. They have very good facilities, and now even in the other states, they are developing it. And I think even, with these court annexed mediation centers, if it fails, then they refer it to arbitration. It's working very well, and most of these states, I think, now have court annexed mediations. On their failure, they swiftly are, referring it. But as Justice Shah said, we can't run away from the truth. Section 11s are pending, and there have been orders passed, by the Supreme Court saying, please get your act together. You cannot delay it anymore, because how can you not get the arbitration process off the ground by even appointing or, substitute appointments? So I think the message is being sent through very effectively to all the courts in the country.
I fully agree with her ladyship. Only few things. See, as her ladyship has very rightly pointed out, that there are certain other cities or institutions where arbitrations are taking place, but essentially they are concentrated on some mega cities. One of the major factors, as I see it, is the equipped judges who will deal with 34 and 37 proceedings in those cities. For example, if you go to some other states, maybe because of lack of experience or less number of arbitration matters being dealt with, the parties may choose not to go there and take a chance. But just visualize a situation where, when we talk about India being the hub of the arbitration, rather than thinking in terms of Delhi or Bombay or Madras or Hyderabad, this is of course a little long shot and a little ambitious thought. But can we not have an arbitration city with its own infrastructure and with its own adjudicatory mechanism, in the sense that we can have a city which would be an arbitration hub for the entire nation, where foreign arbitrators also come, where foreign parties also can come, domestic arbitrations also take place. There are places where the arbitration can take place. There are separate courts in that city itself, taking up 34 and 37 proceedings, and with all ancillary facilities like secretarial services, etc., etc. And there can be appointment of the judges who are experts in arbitration, who can be given imparted kind of training, may not be a correct word, but imparted kind of a knowledge as to how to speedily deal with such disputes because of the very nature of the proceedings involved. If this can be done, then only possibly India can really become the hub of the arbitration center. It can be like a small Singapore within India, with its own, if possible, curial law, with, which also can be thought of. Of course, it's a very, very ambitious project, and people who are really knowledgeable, like Her Ladyship or seasoned people like Mr. Karia, will have to contribute what is to be done, what cannot be done, etc., etc. But if that can be done, then I think India would be a preferred and natural choice for the world to come and arbitrate.
Thank you, sir. I think it's a very, very modern and innovative idea. Something not similar, but on similar lines is there in Dubai with the IFC. We could take some guidance from some of those setups across the world. And as an arbitration practitioner, I can only hope that whenever this city comes up, it is by the beach. So everybody has another reason to be there. I will now move on to another milestone in the last 10 years, as we have seen 2015 amendments, 2019 amendments, judicial pronouncements, and so many things that have been done to actually make India a hub of international commercial arbitration. But a very recent milestone that we saw was 10th March 23, when Bar Council of India came out with the rules for registration and regulation of foreign lawyers and foreign law firms in India. I would request Mr. Manan Kumar Mishra, Senior Advocate and Chairman Bar Council of India, to give his views that how is it going to impact the arbitration practice in India. I feel that your views originally are that it is only going to enhance and augment what we already have, and there is no reason to worry for anybody. If you could share your views on this, sir.
See, for last 10 years, this was under the discussion of the Bar Council of India. Earlier it was very strongly opposed by the common lawyers. And for the kind information of this gathering, even the self people, they were opposing, telling Bar Council of India that still the situation is not very cordial for us, not very suitable for us, because our lawyers, our law firms, they'll be lagging behind. They won't be compete with the foreign law firms and all that. We studied the things and we found, see, what is the purpose of this, your IDRC? To attract the foreign lawyers, to attract the foreign clients. And we thought that unless we open up the doors, as per our information, about 200 international law firms are registered in UK. UK is the country which influenced us more. Because of this, that several Indian law firms are also operating there. We thought that unless we open up the door, we have opened up to a very limited extent up till now. They can't practice in Indian laws because we are not allowed to practice their laws in their country. The budding law firms of our country, the young lawyers, the 5-year products, you know, they are very, very good, and they are very much in demand in UK or US, in very developed countries. So it was actually, we thought that one of the reasons for this not making India a hub of the arbitration, that is, we are not allowing them. Singapore or the other countries, London, this, that, they have been allowing reciprocity. You might have seen in our rules, reciprocity is the main thing to be considered before allowing any law firm, foreign law firm to be registered here in India by Bar Council of India. See, many things, we have to learn many things from the expert foreign lawyers and the law firms. Our young lawyers will have to learn. Unless we involve young lawyers with these expert foreign lawyers or foreign law firms, we can't think that India will become an arbitration hub in the near future. So the Bar Council of India has come out with these rules. There may be certain demerits in course of time, and with the experience, we will see if any changes will be needed, required, we'll do it. But let us start and let us hope. I think that many queries, many foreign law firms, they have come to Bar Council of India for the queries, whatever, how we can get registered here. We have involved the government also in order to ensure the complete reciprocity, so that our law firms or our lawyers may not be put to any loss. We have involved our ministry. We have involved the foreign, ministry, in order to ensure whether our lawyers and our law firms are also treated in the similar fashion in that the respective country or not. So let us hope for the good. In the near future, I think that our rule that will help making India an arbitration.
Thank you, sir. I can assure you, I don't speak for everyone, but majority of arbitration practitioners are extremely happy with this move. And on their behalf, I would like to congratulate you on taking this bold move. I would now move on to Mr. Ratan K. Singh, Senior Advocate. There have been so many institutions in India who have been providing institutional arbitration services, right from DIAC in the Delhi High Court, we have MCI in Mumbai, IDRC here. Now there is another institute that has been set up with the help and aid of the Government of India, IIAC. Most of these credible institutions have state-of-the-art infrastructure. They have been able to make best possible rules in terms of which are comparable to any international institution in the world, and of course a very, very credible pool of arbitrators. Now, do you think all of these institutions being set up in the last 10-15 years, and now the recent example of IIAC, which is starting with a very ambitious sort of a project, because when the Government of India has shown faith and interest in an institution, of course, it has to become a success story in due course. Do you think all of this is going to impact the mind of foreign users of arbitration? Would they be interested in using not just India as a seat, but these institutions, even if they do not initially want India as a seat? Do you see this is going to happen anytime soon, where IIAC or IDRC rules will be applied even if India is not the seat?
Thank you, Shashank. The question you asked me was in some ways addressed by a ladyship, Justice Malhotra, and Solicitor General, on what constitutes a safe seat or efficient seat. Chartered Institute of Arbitrators, London, of which I have directed in India for 12 years. In its centenary year in 2015, came out with 10 principles, which in international arbitration world, people also call it as 10 commandments. First is law, quality of law and legislation of the seat. Second is judiciary, independence and quality of the judiciary. Legal expertise available in that seat, which will really improve immensely with the opening up of India's door for foreign law firms. And credit goes to Mr. Mishra for that. Education for holistically for this particular field. And right of representation. And I'll read what this principle, centenary principle, exactly says about this. A clear right for parties to be represented at arbitration by party representatives, including but not limited to legal counsel of their choice, whether from inside or outside the seat. That is again now available to India because of this opening up of this. And congratulations, Mr. Mishra, for that. Accessibility and safety. That's again an important aspect for all foreign firms and all foreign arbitration practitioners. Facilities, which you talked about, ethics, enforceability of award, and immunity of arbitrators from civil liabilities. Before I talk about Indian arbitration institution, allow me to say a few words about what leadership said about, and Mr. Mehta also talked about, as specialized benches. From 12th to 17th of this April, last month, I was in Singapore, and I had occasion to speak in an event in Singapore Supreme Court, and I had lunch with 4 Supreme Court judges. Justice Kumaraswamy, who sits in High Court there, because their High Court and Court of Appeal house is housed in one building, and together it is called Supreme Court. He told me one thing which is very interesting. I didn't know this for long. He said that in Singapore, the high courts give accreditation to specialized lawyers, such as accreditation to construction lawyers. So you have accredited lawyers doing construction practice in high courts or in arbitration. When it comes to appointment as judges, the judges are again chosen from those particular specializations for specialized benches, which my ladyship was talking about. And those people end up becoming arbitrator. So if we are talking about the roadmap, this is one way to look at it, because that also takes care of the concern about quality of judgments in our courts for particular specialized subjects such as construction arbitrations, which constitutes approximately 60% of arbitration in India. So that was my take on this. And so far as arbitral institutions in India is concerned, let us be honest to ourselves. If you are talking from the perspective, global perspective, whether we have any credible international arbitration institution, ladies and gentlemen, we'll have to be honest to ourselves. We do not have any credible international arbitration institutions from the perspective of foreign or international arbitration community. Yes, things are moving in right direction. 2015 onwards, everything, all stakeholders, whether it is judiciary, legislature, executive, lawyers community, all doing very well. But we do not have any credible arbitration institution so far. In fact, I'm happy that this IDRC, when it was inaugurated in 2020, I had occasion to give a speech in the inaugural ceremony when Justice Sikri was there. And I'm happy to note and see that it has done so many arbitrations. So we are very optimistic about our institutions. Delhi High Court has got its court and extra arbitration institutions. We are, it is the kind of caseload we have with Delhi International Arbitration Center, it is really phenomenal. However, I have a concern because we have to be honest to ourselves. We have amazing pool of retired judges, former judges, who are amazing world-class decision makers. But Shashank, we need to be honest to ourselves. When it comes to the selection of arbitrators by the institutions, problem lies there. Selection of arbitrator is an important aspect because arbitration historically was chosen for people who are having domain knowledge. So therefore, if we are appointing, our institutions are appointing arbitrators from the pool of the existing retired judges, lawyers, and other stakeholders, they should give due consideration to expertise of the arbitrators who are being chosen. But so far as IIAC is concerned, one particular suggestion to make it more credible, you need to have diversity in the governing body. You need to have arbitrators from different jurisdictions. You need to have diversity so that this cross-culturalism really helps the institutions in India as an arbitration hub. Thank you very much.
Fortunately, Mr. Singh, I'm aware that leadership is also part of the chambers of arbitrator that has been appointed by IAC. So your suggestions will be now very well taken by ma'am and will be taken into account for any future developments. But before I move forward, I just wanted to hear from Mr. Tejas Karya if he shares the same view as far as the present scenario of Indian institutions providing arbitration services are concerned. Would you also agree with Mr. Singh that we do not have any existing credible institution and we are still far away from achieving that?
Thank you, Shashank. Good afternoon, good evening, everyone. So I have a slightly different view, with due respect with Mr. Singh, in terms of the institutionalization of arbitration in India. As far as arbitration in India is concerned, it has always been ad hoc till very recent time. Slowly and steadily, we are moving towards institutionalization of arbitration. 2019 amendments were made only to promote institutional arbitration. We have number of institutions across India. The only problem is that we don't have a one prominent institution which we can call is an institution of eminence. And that's why the ICADR, which was originally there in Vasant Kunj in Delhi, was taken over by the Honorable Supreme Court when Justice Thakur was the Chief Justice, and the Niti Aayog conference was organized during his tenure. Subsequently, there was a statute which was passed for New Delhi International Arbitration Center. That was passed at the same time when 2015 amendments came in on the same day. And then it was renamed as India International Arbitration Center. The problem with India is that we are competing ourselves with London and Singapore or Paris. Whereas India, given the size, given the diversity, and the kind of talent we have, or talent pool we have in India, it's very difficult to have the consistency. So what we need to do is that without competing with each other, we need to set up a pool of Indian arbitral institutions who can have the common goal or the purpose of to have the institutional arbitration. And that is where once 2019 amendments will be notified, we will have an arbitration council of India. I don't know, personally, I don't agree of controlling arbitration because party autonomy is very important for arbitrations. But at least it will streamline the whole process of at least appointment of an arbitrators, because the best part in that amendment is that the appointment of an arbitrators will be taken away from the High Court or the Supreme Court for International Commercial Arbitration and given to the arbitral institutions. And we heard leadership saying that there are too many Section 11 petitions are pending. Now with this recent judgment on stamping, it will delay the appointment further. because unless the document is stamped, the arbitrator cannot be appointed. So those are the hurdles we are facing. Once we have the arbitral institutions appointing arbitrators, they have their own time-tested rules. Emergency arbitrators can be appointed within 2 days, and the emergency award can come within 14 days of the appointment of the emergency arbitrators. We have the fund holding facilities, that the infrastructure of the institutions are there. We have seen all the institutions have the infrastructure. They scrutinize the award and ensure that timelines are met. In many of the institutions, when we are appointed an arbitrator, we have to give our calendar for next 2 years to say that we are available. Because availability is one other aspect other than the expertise. Of course, they take into the expertise the amount in dispute before selecting the arbitrators. They have the panel of arbitrators. Some institutions like SIAC have reserved panel of arbitrators for the arbitrators who want to specialize in sitting as arbitrators. So those are the advantages of institutional arbitrations. We have number of institutions in India, and what I have personally known from Justice Hemant Gupta, who is chairing the IISc, is that he is trying to take everybody together. He has made, the institution has made a very diverse panel for selecting the arbitrators. Everything is notified, so there is a transparency in this institution. And also they have called all the law firms and the lawyers and the stakeholders to give views on the rules. So I'm very sure that this institution, along with other institutions, will take our dream of making India as the institutionalized arbitration further. And automatically it will be the hub of international arbitration. So I think IISc is a step in right direction. The name itself connotes, so if somebody is outside India, they will think that it's a credible institution with the backing of government of India. It has been pending, but I would say better late than never. So we have to then move forward and see that we have more and more institutionalized arbitration in India, and we have to change the mindset of the people who are drafting the arbitration agreement to put at least one. They can select any one of them, and all of them are good. We have to all work together to make them good institutions and be part of all of them rather than some of them. And capacity building is very important. So we are all, Mrs. Ratan Singh and I are part of Chartered Institute of Arbitrators, and they give the accreditation of the membership and fellowship. And that comes after rigorous training as the arbitrators who sit as an arbitrator. So we have to have more and more expert arbitrators in India, irrespective of their background. It could be from the law, accountancy, engineering, and all these arbitrators have proven to be the excellent arbitrators with the minimalistic judicial interference, because we have also seen the courts have changed their approach towards the arbitral award, and they are not setting aside the awards for asking. Many courts like Delhi High Court have started deciding Section 34 in the first hearing itself without even issuing notice, because there is an advance copy served and the other side is present. So those are very positive development, and we have a lot more to achieve, but we have come a long way in last 7 to 8 years, in my view.
Thank you, Tejas. In fact, one of the suggestions that can be used to address the problem that was indicated by Mr. Ratan Singh is that when the drafting of the contract is taking place and you have a dispute, there is a likelihood of a dispute in a construction setup or a maritime setup, you have the ability to prescribe certain qualifications for the arbitrator. So taking away that discretion from the appointing authority, whether it is court or institution. So I think that would be the first and the simplest way to ensure that the specialists are appointed as arbitrator if and when a dispute arises. And I think it is already in place. Many government sector undertakings, PSUs, have already incorporated clauses where they specify the person should have experience in engineering or some sort of specialization is indicated in the clause itself. Something that came out of what Tejas has stated with respect to asking for calendars of arbitrators in advance for 2 years, that is being done by all the credible institutes across the world, we have prescribed timelines for arbitrations to get over within 18 months under Section 29A. Before I ask my question to Honorable Justice Indu Malhotra, I'll just give an example, ma'am, and then would come back to the question. Not naming an arbitrator, but I had the occasion of having a disclosure of an arbitrator from a previous arbitration, wherein the arbitrator indicated that he has 55 odd arbitrations ongoing. And in a Section 11 petition, I showed that to the court when the so-called arbitrator's name was being suggested by the other side, that while I have no objection, but the disclosure in one of the arbitrations I'm doing shows that the learned arbitrator already has 55 matters. The High Court said, no, we have no doubt in the efficiency and capacity of the arbitrator. This is a good name, let's go ahead with it. So the question really is, while so many things have been done in the last 5-7 years, and the Arbitration Conciliation Act went through overhaul in 2015 and 2019, several things were achieved, but many of them are really on paper because there are no consequences of not following that. So what are the key misses of the Arbitration Conciliation Act 2015 and further amended in 2019, which requires immediate attention?
In my view, another set of amendments is now necessary to be done, particularly with respect to the period of limitation on Section 11, Section 37, and Section 47. There is no limitation period prescribed. It's by judicial interpretation that a period of limitation has now been pronounced for each of these, but I think it requires a legislative amendment. Now, that is one part. The second part, where I, frankly speaking, personally feel that under Section 13, if there is a challenge with respect to the impartiality and independence of an arbitrator, the tribunal decides that it has no merit. It goes for judicial scrutiny only after the final award is passed, which I think is incorrect. It should be done there and then, and that is what the uncitral model law contemplated, and that's what even the English Arbitration Act contemplates. Because suppose it turns out to be correct at the time of judicial scrutiny that there was lack of independence and impartiality, you have dragged the parties through a very costly proceeding, financially and in terms of time. And then you find at the end of the day that they lacked independence and the entire proceeding, falls through. So that is one amendment which I do feel should be brought about. We should not postpone it till the final award is passed. Another aspect is that even though we have accepted the IBA rules on conflict of interest, which has helped, there is no sequitur to it. That is, if a person doesn't follow it. I remember while I was in office, there was an arbitrator who had done some 50s or 70 arbitrations of a particular party. So I said, you're conflicted out. So then one of the counsel for that party said, no, please don't remove him. There are so many awards passed. I said, you can't have these kind of awards being passed. It's straight away, he's conflicted out. Now the problem is that there was, I remember, a matter where the arbitrator refused to give his declaration. He said, do what you can. There's nothing in the act. So there are certain proceedings, certain provisions which need to be incorporated to give effect with respect to disclosure of interest, because in arbitration, the most important aspect is the integrity of the arbitrator. Otherwise, the process is a meaningless one. Similarly, there are even Section 21, I feel, on commencement of arbitral proceedings. It should be when the arbitrator enters upon reference and not really when there's a mere issuance of notice. So I do think a fresh set of amendments should be gone into. But let me put the positives. I think most positive aspect of our act came in 2015 when a timeline was framed, and that has really helped that, proceedings get concluded within a period of, 2 years or 2.5 years at best. If there are extensions given, so proceed, matters get concluded. In fact, I think this is the most salutary principle which has been incorporated in our Act. Apart from this are the IBA guidelines, Schedule 5, Schedule 7, which have a statutory flavor in our Act, which it is not so. There's soft law in other countries. That is another aspect which I think is very salutary.
Thank you very much, ma'am. In fact, let me say very candidly, the entire arbitration community is indebted to one of the landmark judgments that you had pronounced in Perkins, really setting the tone right and completely doing away with unilateral appointments, because that was, I think, a very short-sighted idea which NBFCs or developers used to implement and harass the weaker party. So thank you very much for that. Now I'll move on to the Learned Solicitor General of India. So there is an inherent perception of bias when the state entities get involved internationally. So we have seen some examples. For example, China and Russia are popularly, or I would say are infamous for their sovereign intervention in the arbitration process. We have somehow managed a clean reputation so far, and with these amendments and all the necessary steps being taken by all the stakeholders, I hope that our image will be sustained as clean. But what do you think are the steps that should be taken by the government or by the judiciary to ensure that there is no perception of bias in the way we arbitrate in India, especially when public sector undertaking or government of India is a party?
See, let's not compare India with China, because nobody in the world does. Number two, I don't personally feel that there is any perception, so far as India is concerned, that there is any institutional bias or any, as you rightly used the word, sovereign interference. That is, I don't think, an issue so far as India as an arbitration center is concerned. If you go by the number of arbitration awards which go in favor of either the government of India or in favor of the public sector undertakings, and the number of awards going against them, also withstand the test that there is no interference or there is no institutional bias, so to say. We can legislatively do nothing to remove that doubt, if at all someone has that doubt. I think our credentials in these aspects can be proved only by the result which we get in the arbitration procedure. There cannot be any straitjacket formula which can be employed either by the executive or by the legislature to ensure that there would not be any misconception of any bias, because you can't deal with misconceptions by any legislative provision or by any executive action also. It is always the things which speak for themselves.
Thank you, sir. Mr. Manan Kumar Mishra, sir, if you have any views on this.
I fully agree with the learned Solicitor General on this.
Now I'll move on to Mr. Ratan Singh. Already addressed in detail by a ladyship and the Learned Solicitor General of India, the aspect of delay in execution and enforcement proceedings. However, it still remains one of the most critical factors in, or hurdle in, making India a preferred seat. What do you think can be done immediately to ensure that the delays that are being seen in courts for various reasons, whether it is because of the fault of the judiciary, whether it is because of the fault of the lawyers, whether it is because of the fault of any other stakeholders, ultimately the perception, because of our track record in execution proceedings in the last 10-15 years, has been not so heartening. What steps can be taken collectively as all the stakeholders in India to ensure that the enforcement proceedings can be expedited and this perception can be changed?
I'll take one step backwards and I'll share my thoughts on the efficiency and the ways in which arbitral delays can be taken care of, because it is directly linked with the delays in enforcement proceedings or annulment proceedings. Two things if we are in a position to do during arbitral proceedings that will immensely help the whole ecosystem. One, hearings, that means opening submission, cross-examination, and closing submissions, or oral arguments or final arguments, whatever we call it. This should be done in one stretch, at the max 2 stretch, with a very limited number of days of gap. That is one thing which I think is very, very important. And to streamline the process, we should follow the chess clock method, which is generally followed, in international commercial arbitration work. That means that both sides are assigned limited number of hours, and so that they know how to use those limited number of hours, whether they use it for cross-examination of one witness, all witnesses, or for opening, or for closing submission. That is one thing. Two, we need to go towards the international best practices these days, which is written advocacy gets precedence over oral advocacy. Gone the days when oral advocacy used to be the norm. So that is one. And third thing is, and which is the biggest problem in Indian arbitration system, which really adversely affects the quality of awards, is till the date of final arguments, most of the arbitrators would not be aware of the disputes between the parties. Therefore, like yesterday only, I was sitting in a tribunal, and we have said on the very first day, both sides will tell us as a tribunal what are the disputes between the parties in 20 minutes at this stage, so that at least we get to know what is the dispute, so that tribunal gets into the control of the proceeding. Otherwise, we have seen situation, as a lawyer I have seen international arbitration seated in India, there is thousands of hours spent on discovery, disclosure process, reference schedule is exchanged, but when it comes for ruling before the tribunal on whether the parties should disclose a particular set of documents or not, tribunal comes and says, do you expect us to know what is relevant, what is not relevant at this stage? This is really not something we should be proud about. So therefore, that is one thing. So far as delays in courts is concerned, my understanding is only answer is training, training, and training. Training of our judges, sensitization, and they have to be told, as you also said, Tejas also said, and in fact, Mr. Mehta also talked about this. Delhi, Mumbai, Calcutta, Madras are exceptions. You go to any other courts and in other jurisdictions in India, all matters go to district courts. There, all these annulment proceedings are treated as any other civil suit. So very first day, you are not supposed to even appear. They will, in routine manner, notice will be issued. Unlike Delhi High Court, where on the very first day it is done. So training of our judges at all levels. I am doing many international arbitration disputes in high courts in India, and I can say that we need to have more and more education and training for our judges.
Permission, and on a completely lighter note, the moment you use the word training for the judges, there would be an inbuilt resistance to be trained. Judges are not trained, they undergo orientation.
I would agree with Mr. Ratan Singh, and I'm also of the view that refresher courses, if that's a more palatable term, they must be done, particularly in view of investment treaty claims which are being made against the Republic of India. I think the judges need to understand the impact of various cases which come before them, and judicial delays has also been the cause for an investment treaty award being passed against the government of India in the white industries case. So I am certainly of the same view. I'm not averse to any training. In fact, I often tell my colleagues, we do so much of construction arbitrations, we require some training in that. And, we should have these courses. And in fact, in 2017, I had gone to London for the Chartered Institute of Arbitrators course and eventually became a fellow. So I also sat down and took exams, which was just before 1 year of my elevation. So I'm really not averse to it. And I would also recommend it highly that training is required, particularly in district courts, that they shouldn't treat a section 34 like, as an ordinary civil matter. They must understand the confines within which it is to be decided.
Just to, with permission again, just to add to what Learned Solicitor General said, is that orientation is the right word, and when we go to National Judicial Academy, we are called resource persons. So that is something is good that we are having judges coming to this judicial academies, and the kind of question we face as resource persons there, sometimes we feel that it's good that there is this kind of a roundtable discussion happening there, and they can share their issues very frankly, because many times from the practitioner's perspective, we think differently, and from the judge's perspective, there is a completely different perspective. So there is a ongoing process. We need to do it more, but with this orientation and continuous learning process and unlearning process, we should be able to achieve our goal in terms of having the consistency across India in terms of the judicial pronouncement.
Shashank, allow me to say one thing, interject here. Since Mr. Misra is here, I have one suggestion to make about mandatory continuing learning program in India. Professor Madhav Menon had initiated this process, and Professor Menon had told me that he was in touch with Bar Council of India, with Government of India. He had started under the umbrella of M.K. Nambiar Trust for continuing learning program for lawyers. And I had occasion, and Professor Menon had requested me to design a 5-day course on arbitration for that continuing learning program. And we used to go, Tejas, we all used to go for 5 days in Kochi to train lawyers. Mr. Misra, I'll urge you to take up this with all seriousness, what you have in your command, because you have taken such a bold step. That is one thing. Will really enhance the ability of practicing lawyers, which in turn will give you better judges, which in turn will give you better arbitrators. So I'll urge you to look at it with all seriousness.
For the kind information of honorable panelist and the gathering, under the continuous legal education program of Bar Council of India, like foreign countries, we are going to frame the rule that in course of 5 years, at least 40 days, every lawyer will have to go some compulsory training. Only then their licenses will be renewed. I know the Bar Council of India and the other state bar councils will have to face a lot of protests and agitations. But since it is for the benefit of the future of this legal fraternity and our profession, under the guidance of our Honorable Solicitor General of India, we are going to frame the rules, and in the year 2023 itself, this will be implemented.
Thank you. Now, with the permission of the chair, I would like to close the panel discussion as we have reached the deadline that was given to us. I'm sure there are many curious minds with many questions. I urge that you find some of the panelists outside once the session is over and ask questions, or write to some of us. Given the paucity of time, it would not be possible to take any questions from the audience. But I'm sure everybody has enjoyed and is going home with some new learnings. Thank you so much.
Thank you, Shashank sir, and all the panelists for such a wonderful session. It has been a pleasure and a significant learning experience hearing the insightful views of our esteemed panelists on the Arbitrate in India Conclave. Apologies. May I please request Manan Mishra sir for his valedictory speech? I request everyone to please be seated.
See, the pulse of audience, I see that it's not a time for the long speech anymore. As a student of law, see this arbitration, we are in litigation field from the very beginning. The arbitration, big law firms are really very alien things for most of the lawyers, the majority. He is a very good arbitrator. I may be a very good lawyer in the civil side or criminal side, but nowadays, he is a very good arbitrator. He has so many arbitration cases. This irks those who are in the field of arbitration, in the field of litigation. That is why it is my earnest request and appeal to the young lawyers. Arbitration is not a very difficult thing. Arbitration, this mediation, many of us can do very well. But I think that these fields and this area has been pocketed by a few. This is a very harsh truth I am telling. Maybe looking bad for some of us, but this is the harsh truth. It has to be decentralized, and it will be decentralized only when we all sincerely try to involve in it. Honorable, the chairperson of today's panel is here. As a representative of the Bar Council of India, as a representative of the bar, one question has always been raised by the general bar. Why only the judges are being appointed as the arbitrators? Why not the lawyers? Our Honorable Chief Justice of India at one point of time, in one of the speech, I was also there on the dais, he said that our young lawyers should also be appointed as the arbitrators. It looked very good. But it's only confined in the speeches and in some articles. Practically, we are not finding it. Therefore, all of us should learn to arbitrate and should involve ourselves in those proceedings. And the authorities, the highest representative of our government is here. I'll request on behalf of the bar of the country that something should be done so that the lawyers, those who are interested, those who are deserving, those who are competent, they should also get the opportunity to be the arbitrators to arbitrate. These are the few things which I am leaving for you all to consider for the future of this legal profession. Many things the panelists have discussed. What are the problems in making our India a hub of the arbitration? The suggestions, I think, might have benefited most of you. And we are on right track. Very soon, the things will change, and hopefully, with the help of, with the active cooperation of these institutions and bodies like IRDC, we are going to be the hub for the international arbitrations also. Thank you all.
Thank you, Manan sir, for your kind words. It has been a pleasure and a significant learning experience hearing the insightful views of our esteemed panelists on the Arbitrate in India Conclave. I firmly believe that the exchange of thoughts and ideas that have taken place at today's conclave will garner long-term benefits in the field of arbitration and dispute resolution. We are sure that the views expressed and concerns shared today shall have a positive bearing on the arbitral environment. I'm highly grateful to Honorable Mr. Justice M.R. Shah sir for joining us and inspiring us in many wonderful ways. As young lawyers, he has always encouraged us to come forward and work hard. My sincere thanks to Justice Indu Malhotra ma'am and Tushar Mehta sir for being so kind and joining us on the panel. My heartfelt gratitude to Manan Mishra sir and the Bar Council of India for joining us and also partnering with us as the principal academic partner. I would also like to take this opportunity to express heartfelt appreciation for Tejas Karya sir, Ratan Singh sir, for taking out the time out of their busy schedules and gracing the conclave, which marks the 3rd anniversary of the Indian Dispute Resolution Center. My special thanks to our moderator, Shashank Garg sir. I would also like to thank our supporting organizations. Without their support, this conclave would not have been successful. I would like to thank India International University of Legal Education and Research, Shardul Amarchand and Mangaldas Law Firm, Chambers of Ratan K. Singh sir, SNG and Partners, Sandeep Logistics, Ratan India, Lexidum and Rathi, Revolt, Punjab National Bank, Torrent Pharma, DG Cables, Neopay, Texortium, Splendor Group, Makalka Developers, Expressions 360, TrademarkClick.com. I would like to thank our knowledge partners, National Law University Delhi, OP Jindal Global University, Vivekananda Institute of Professional Studies, Galgotia University, India Institute of Arbitration, and India Institute of Mediation. I would like to thank our media partners for covering today's conclave. Latestlaws.com, Haribhumi, Janta TV, Z News. I would like to extend a special gratitude to our respected advisory board members who are always available for us to guide and support us. A special thanks to Sanjay Rathi sir Tanmay Mehta sir, Rashmi Gogoi ma'am, and Satish Daya sir for their constant support and guidance. I would like to thank Mohit Gupta sir and for helping us organize the conclave and his entire team. I would like to thank Shri Manoj Sharma sir, our IT head, and his team for working tirelessly to develop IDRC's EADR software, website, and cloud infra. I would like to thank our team members, Sheetal June, Sunny Chikara, Akash Kashyap, guests, and audience for joining us at the conclave today. We are highly obliged to have you today with us. I would like to thank Ambedkar International Center, their staff, and service providers. With this, we conclude the Arbitrate in India Conclave 2023, and we request everybody to please be seated and allow the first 5 rows to exit first. Thank you, everybody. Please enjoy the evening. People at the back, please be seated. Please allow the first few rows to vacate, please. Thank you.
The high tea is at foyer area on the first floor. The high tea is on the first floor.